Hey guys, my name is Shashwat and I am a legal intern at LEXIS and Company. I may start by saying that the Constitution of India is the supreme law of the land which lays down the rules and the regulations for the protection of the rights of the people and impose duties over them. This vast literature is considered as the guardian and protector of the fundamental rights guaranteed to an individual. The rights of the writs is one of such right available to the people of the country. The provisions of Indian constitutions are sanctioned by law. Thus, judiciary has the independent authority over the matters in such writs by the law are to be used. The concept of the writs is so to enable the immediate determination of the rights of an individual and help the persons to achieve the benefit of this right. There are 5 types of writs in our constitution. First, there is the writ of habeas corpus, then writ of mandamus, thirdly writ of prohibition, fourth the writ of certiorari, and the last one writ of quo warranto. In this video, I will be telling you about the writ of habeas corpus. So, what is the meaning of writ of habeas corpus? The writ of habeas corpus is the legal procedure which acts as a remedial measure for the person who is illegally detained. The term habeas corpus is the Latin word which means to bring or present the body before the court. It is the most important right available to the person who has been detained unlawfully. The basic purpose for which the writ is used is to release the person from unlawful detention or imprisonment. This writ is of great importance as it determines the person his rights or right to freedom and personal liability. The nature of writ of habeas corpus is that it can be traced way back in the 13th century. The writ of habeas corpus is an order calling upon the person who has detained another person to present the person in the court and justify his actions that on the grounds of his actions are with the authority have been confined or not. If the court doesn't find any legal jurisdiction for the cause, then it will order for the immediate release of the person confined or imprisoned. Habeas corpus may be applied to the person who has been confined or detained illegally, who is the person who is aware of the benefits of the case, and the person who is familiar with the facts and circumstances of the case and willingly files an application of the writ of habeas corpus under the Article 32 and Article 26 of the Indian Constitution. The writ of habeas corpus is also refused sometimes. The court can refuse it when it doesn't have the territorial jurisdiction over the detainer. Also, it can be refused when the detention of the person is connected with the order of the court, or when the person detained is already set free, and if the writ of habeas corpus is refused when there is a time of an emergency in the country. Then there are some cases regarding the habeas corpus. One is very important, that is the Additional District Magistrate of Jabalpur versus Shiv Kant Shukla in 1976. This case is also known as the habeas corpus case, and it was based upon the grounds of issuance and viability aspects of this writ. This whole spins around the situation when the emergency was proclaimed and the question was raised whether the writ of habeas corpus is maintainable in this situation or not. It was held that in the case of Liverside versus Anderson, that the rights are held suspended. The same was held in the instant case where the state has the power to restrain the rights, especially the right to life enshrined under the Article 21 of the Indian Constitution in the state of emergency. This decision was considered as the darkest day of the Indian history. So I may conclude by saying that it can be that the rights of writs is one of the such a right available to the person under the provisions of Indian Constitution, and the concept of the writs is to be enacted on immediate determination of the rights of the individual and help the person to achieve benefits of his rights. Thank you.